Well, we'll move on now to the next item. As you may have seen there, we're joined now by His Excellency Dave Umahi, Governor of Ebonyi State. He joins us virtually this morning. Good morning, Your Excellency, and thank you for joining us on the program today. We're starting off.
Good morning, Chamberlain.
Okay.
Good to be on your program.
Thank you. Well, let's start off with this matter about Ebonyi South senatorial election. There's a lot of hoopla about what's going on, what's happening, how did all of this happen. So if you could give us your impression about what the crux of this matter is, because at the moment, the information out there is that the court says there has to be fresh election. So tell us about that. What is actually going on here?
Chamberlain, thank you very much. I decided to appear on this show just for three key issues. One is to throw light on this Section 115 of the Electoral Act for the benefit of Nigerians. Second one is to correct a channel. They have corrected themselves where they say court disqualifies Dave Umahi for Ebonyi South Senatorial Zone. And three, to assure channel that I'm not here to demarcate my subject. So by every means, I'll try as much as possible not to demarcate my subjects because they are my treasures, as far as leadership is concerned. So the fact remains that I have not seen the court judgment. I think it may be available today, but I've asked those who went to court, and I've spoken to the ANEC lawyer that was in court, and the ANEC lawyer said two things: that the court ordered for fresh election, and that I was never disqualified. So this is very important. And what really happened in the court? I think what happened in the court by the judge cancelling the election of 9th of June may not be the fault of the judge. The judge made use of the evidence before him. The lawyer went to court because INEC did not publish my name as submitted by the party APC. And so the lawyer went to court on my behalf, within the 14 days that the publication of INEC came out. And so to compare INEC to do that. And then along the line, even a PDP from my senatorial zone, who is a senator now, joined the suit. And I say he's been very ignorant of the law. And the person that came second in the first senatorial primary, also joined the suit, my sister Anna Gomez. And so the lawyer raised objection that Section 285, subsection 9 of the Constitution of the Federal Republic of Nigeria makes it clear that those people joining, that their suits are status barred. And what is his opinion? The opinion is that the subject matter is the election of 9th of June. And from 9th of June to the 20th of July when they joined, it's more than 14 days. Because the Constitution of the Federal Republic of Nigeria says that, and I read, it says, notwithstanding anything to the contrary in the Constitution, every pre-election matter shall be filed not later than 14 days from the date of the occurrence of the event, decision or action complained of in the suit. And I think the subject matter is the election of 9th of June. That is the subject matter. And that event occurred on the 9th of June. And that's what the lawyer fully relied upon. And he did not, counterclaim when they joined the suit. I think that is where the mistake came from.
A lot of people may have been, focused on national matters, the presidential primary in the APC and all of that, and didn't catch exactly what played out, or what has been playing out in Ebonyi State regarding this senatorial race. And you have talked largely about, the primaries. There was one in May, the first one, and then there was from your party asking that, we need to do it again, which is the one you're referring to, June 9th. So regarding the decision of the court, did the court uphold your candidacy for that June 9th primary, which you won? Did the court say, well, yes, you indeed won it, or not?
The court relied on the evidence, before the court. And like I told you, my lawyer relied on Section 285, subsection 9 of the Constitution to say, look, this is, an academic, exercise in futility, because there are cases, both the PDP that joined and the person that came second in the first primary, that there are cases where status bad. And then, what is the situation? The situation is that somebody won, in the first primary, which they did. And Section 30, Section 33 of the Electoral Act, first of all, Section 31 talks about withdrawal of candidate. An aspirant is not a candidate. An aspirant is not a candidate. A candidate is somebody who has been declared a winner of a primary election by the party and the name submitted to INEC. And INEC confirms. It's only INEC that confirms that a candidate is indeed a candidate. And so when the first person that won in the first primary withdrew, according to Section 31, and then Section 33 says that you will hold a fresh election. And that's that fresh election that took place, on 9th of June.
Right.
And INEC was duly notified, and INEC monitored the election, and INEC submitted report. And so, what the person that, because this person that came second in the first primary election, has no case. The Constitution, the Electoral Act did not make mention of anybody coming second. It said, where a candidate withdraws, that there should be fresh election. And so that Electoral Act envisaged that the party should choose the best. Because if the Electoral Act envisages that the second person should come on board, it would have said so, but it wasn't said it should be fresh election.
So I just wanted to be clear.
And that's exactly what the party did.
Right, so I just wanted to be clear on the decision of the court on that June 9th primary. So essentially the court did not uphold your candidacy from that June 9th primary. Essentially said there should be another primary which will now select the eventual candidates or the substantive candidate of your party.
Yes, two things the court said. From account of those who were there, I can't quote the judgment because I've not seen it. But one thing they said is that I believe that my sister Anne misled the court. She lied under oath that she did not withdraw, because she withdrew. And what she didn't know is that all the places she went in the course of withdrawal, they all had cameras and they captured her. And this is, her withdrawal letter, which she submitted to, INEC, submitted to the party, and the party, has given us, true certified copy. So by going to do an affidavit to the court that, one, she didn't know about the rescheduled primary, two, that she did not withdraw. She withdrew twice. And the documents are all there, and we have the true certified copy. So she lied under oath and misled the judge in believing that she did not withdraw, and as such, she did not, she was not notified. But the consequence of that is that she lied under oath, and the consequence of that is that she did not just withdraw from a particular primary, she withdrew from all primaries, in 2023. But the court says, look, do not exclude them. And you can also take new people, in reconducting the primary. So that's what happened. So the court nullified the election of 9th that produced me and said there should be fresh election. And the first 2 people, notwithstanding that 2 of them had withdrawn, should be allowed to join, and that any other new person is also allowed to join.
So does that then, has the court taken any decision on what you just said about her withdrawal? Has anything been done about it by the courts?
Because it was not, our lawyer did not challenge, her counterclaim. Our lawyer relied on the fact that her suit was status bar. But when the judge did not consider that section of the Constitution, which our lawyer submitted, that our case was status bar by reason of section 285 of the Constitution, subsection 9. So that's the real mistake for me by the lawyer, because for me, he would have also claimed, her counterclaim. So that's where the problem of this is, because the election of 9th is perfect, and all the documents are there and are all valid. The INEC monitored it. Let me throw light on this section 115, because that's the real reason why I'm here.
Yeah, Your Excellency, we'll go to that section.
I was very shocked.
Your Excellency, pardon me, we'll go to that section in a minute. But does it then, because the impression out there now is that since your lawyer made a mistake, and since the judges have to act based on what is presented before them, no decision has been taken on what you just spoke about, her lying under oath. The court is not aware of that as of yet. So the substantive decision now is that your candidature was not upheld. Isn't that the way it stands at the moment?
Yes.
So
yes.
On what grounds then can you say that you were not disqualified, since it's a mistake from your lawyer?
Disqualification is different from nullification of a primary election. Disqualification is totally different from nullification of a primary. When you say disqualification, it means that you are not qualified to contest. But nullification of a primary means that that primary is null and void.
Okay, so it's a use of that word, but at the moment, your candidature has not been upheld by the court. So talk to us about section 115 then.
Before I go to before I talk about section 115, I wouldn't say my lawyer made a mistake. No. My lawyer was convinced that by citing section 285 subsection 9 on the issue of statute bar of the counterclaim, that he was sure to win the case, and that there was no need, laboring himself to also counterclaim her counterclaim. So that is the issue. But the judges are always right, and so whatever is the case, I commend the judge very highly for the decision, and nothing has gone wrong. But I see the hand of PDP, the senatorial candidate of Ebonyi South, who joined the suit out of desperation. And somebody who is a lawmaker who does not understand the Electoral Act that they made, not knowing fully well that you cannot, be a party to an election you did not contest. Even looking at this case very, very well, even the APC person should not even challenge the election of 9th of June, because she was not party to the election. But all the same, I'm not a lawyer, but the Constitution and the Electoral Act is, there for all of us to read and understand.
So, Your Excellency,
there are a lot that should be going for me as far as that is concerned. So,
okay, so before
I'm not worried, because
does that mean that if your candidature is not upheld, how are you going to participate in the fresh election within 14 days?
You are putting another interpretation.
No, we're just trying to understand the situation.
The crux of the matter, the crux of the matter is that the election that produced me was nullified by the court. That opportunity was not given to all the, like Anne, who came second in the first primary. But the Constitution, the section, the section of the Electoral Act, said that you have to reconduct where the winner of a primary election withdraws, that you have to reconduct, and then that reconducting the decision does not, give INEC, that 21 days, because a process is on, and the process of primary election, and INEC has been duly notified by the party, that conforms to that 21 days. Now, going to the Electoral Act, where this thing says in Section 31 that where a candidate withdraws, and then in Section 33, then that you have to, what you need to do where a candidate withdraws in Section 33, that you have to within 14 days. And that's what the party did, that within 14 days they complied and notified INEC. And INEC came and they observed the election. So now, the judge relied on the lie told by Anne by saying, look, I was not aware that the candidate has withdrawn. And it's not for you to be aware, because you have to rely on the Electoral Act. And so the party, published in the constituency, look, there will be another election on 9th. And that election held. And the same Anne, incidentally, was in the party secretariat when that decision was taken. And there were cameras everywhere that captured her even when she was signing. And so for me, she lied under oath. At the APC in Ebonyi State, they have taken it up to sue, to say, look, you lied under oath by going to sue affidavit. And again, she also lied by saying that the first primary election, there was no problem. She submitted a petition alleging that there was a disruption of the election by security agencies. And in the affidavit she submitted, she said there was no problem with the primary. She challenged the first primary and said that the person that won did not. But in her affidavit now, she said there was nothing wrong with that primary, and the person, validly won. So that is this thing. But like I said, I would not demarcate my subject, and I can't join issues with her. We obey the court order. But the court did not disqualify me. The court says that there should be a rerun. And both of them, whether they have withdrawn or not, should be given the opportunity to also try again. Well, that's the judgment of the court from what I heard from those who were in court. I have not seen the judgment.
Okay, well, we reached out to her to get clarification on all of these matters that you've spoke about, but she declined comment at the moment, so we don't know if she'll change her mind on that one. But, Your Excellency, we'll go to break. We'll return because there's some areas we'd like you to shed a lot more light on, which was still not clear at the moment, even from the point of law, but that will be when we return. Don't go away.
Thank you for staying with us. Well, Your Excellency, interesting conversations that we've had so far. And one of the questions that comes to my own mind, about this whole thing is, when you say, let's just be clear. You haven't seen the judgment. We haven't either. But I just want to be clear. From what you have heard and, from what you have said, is it a call for fresh elections that the court has asked for, or a rerun? Because, there are implications to the two.
Thank you very much. That's a deep understanding of the matter. The court pronounced rerun, fresh election, and that's what the Electoral Act Section 33, also specified. It say, rerun. Fresh election.
There are those who are wondering if it's a rerun, then your candidature is absolutely obliterated. There is no space for yourself to be a part of that election. Is that something that concerned you? As you said, you haven't seen the judgment, so we're quite clear. Go ahead, Your Excellency.
You're out of order. I've told you that I told you the Electoral Act says fresh election, and you are still dwelling on rerun. And even if you say rerun, How do you mean that I'm out of, the context?
I'm wondering, were you a part of the previous election, the previous senatorial election?
I think there is a need for us to read the Electoral Act very well. The Electoral Act, Section 31, says, a candidate who won the primary, when he withdraws, should do that in writing, and that has been done. Section 33 says that where the candidate withdraws, that the party will conduct fresh primary election. That's what it said. And so it's not looking at the moment a candidate withdraws, it is that primary election is over. That's what the Electoral Act says. And it is there, and if you like, I can read it for you.
Well, Your Excellency, before we get to that one, I'm wondering what, the role of INEC is in all of these, because some would be asking, how come certain names were not in the list that INEC presented?
I'm not an INEC official, but the INEC had no problem publishing my name. It was a matter of time. But, I needed to do something to comply with Section 14 because supposing INEC, have their reasons, which they told me there was no reason not to publish my name, but they were going to publish my name. So I had to comply to that 14 days, mandatory, of the Electoral Act, that you have to go to court to compare INEC. And that's what I did, based on the election of 9th. And that election of 9th was the only one that contested, as far as the thing is concerned. And let me tell you something. There is a Supreme Court decision, Daniel versus INEC, 2015. And it reads that a party has a right to exclude a candidate from participating in primaries, even after he has been screened and cleared to contest the primaries. And the candidate so excluded has no legal remedy against the action taken by the party. So it is the right of the party, to say who and who will, stand the primary election. And let me tell you, for the avoidance of doubt, those who are talking about qualification or not qualification, if you go to the Electoral Act, Section 84, subsection 3, it talks about qualification for primary election, qualification. And so I feel so bad when people come to the faces of televisions and they darken counsel without knowledge, So the question is my qualification. Am I qualified to contest this primary election? And the answer is yes. And then Section 84, subsection 3, is what is given who is qualified, who is not qualified. And you cannot tackle the candidature, the aspirants, based on any other thing, other than the basic qualification to contest the primary election. That's what that section is talking about.
Well, Your Excellency, how about Section 115?
Okay. Great one. The Section 115, I will read subsection D. A person who signs a nomination paper or result form as a candidate in more than one constituency at the same election. So there are three issues here. A person who signs a nomination paper. The question is nomination paper of who? Is it of INEC or of party? Then the second one is result form. What is result form? Is result form the form that is being given by party? Do you define a result? Do you get a result when you have not, sat for an exam? And the answer is no. So the result form here for me is the certificate of return given by political parties to their candidates, the candidates. Or you can define a result form when election is held and INEC gives you, certificate of return. So we are not yet at the INEC level, so we are at the party level. So result form is the form that a return, certificate of return, that party will give to the candidate. And in every primary election, there are no two candidates, it's only one candidate. And so we are talking here about candidates. Now, let's go to a section that, people never went to, and that is section 152. If you have your this thing, you can now go to it, and that's the definition paper. And section 152, he said, definition of who is an aspirant. Say, an aspirant means a person who aspires or seeks or strives to contest an election to a political office, an aspirant. At the level of the party or the primary elections, everyone until primary is held, they are all aspirants. Now, let's go down and see the definition of candidate. Candidate means a person who has secured the nomination of a political party to contest an election for any elective office. A person who has secured the nomination of a political party, who has secured the nomination of a political party. And if you look at INEC timetable, and you find out that it is only INEC that give from, I think 13 EC 13A, and that EC 13A, the last day for such to happen is on 8th of August. It's still in front. So it is only INEC that confirms who is a candidate, and they will issue a form to the party to give to the candidate to fill. So people darken this section 115 without knowledge. There is nobody who is a candidate until you have been duly nominated, according to the electoral act by the political party, submitted to INEC. INEC will now issue a form to the party to give to you, you will fill. And that is the nomination form. It only comes from INEC.
Your Excellency, there's one other word that you may want to speak to as well. You've spoken to nomination paper, you've spoken to result, and you have, of course, spoken to candidate. How about the fact in that same portion that talks about more than one constituency at the same election? It is not possible for one person to contest for presidency and to become a candidate for presidential and senatorial election at the same time in one election, or is it?
That is where the media is giving their own interpretation or bringing something into the Electoral Act. You see, this Electoral Act is the ingenuity of the lawmakers, and when they were making this, they needed to look at decided cases of the Supreme Court. And this section, what it envisaged is what happened in Imo State governorship election, where Uchenwosu became the candidate of AA and the candidate of APC. And the Supreme Court said, no, you cannot be a candidate, of two different political parties, or be two candidates, at the same time in one election. That's what it's envisaged. And so when the business of a political party is the business of a political party. You can have 20 forms, you can have 30 forms. But let me even throw light on that. The APC presidential election ended on 7th of May. And by 7th of May, there were no more aspirants. We understand. So there were no more aspirants. The time to appeal the decision of that convention had passed. And so the presidential election had been concluded. And so there was no more, aspirant. We produced a candidate. And so, clear stated this, the candidate of the party withdrew. And so you are saying that the party has no right to, do another primary. And so I bought my form on 9th of June. So there was no time I had two forms, so to say, at the same time, you know. So when the primary had ended and that matter is closed, and then I now came on the 9th of June and then bought a form to contest. So I was never holding two forms of political party at the same time, even to argue along your line, even though it's very unconstitutional and on the electoral act.
Yeah, but Your Excellency, the thing is, trying to look at this section, I mean, you will always say that we can't, the rule of interpretation is that we have to look at other relevant sections to try and understand the intendment of the drafters or the lawmakers on this. And some say, look, that if we go to section 29 and 30, it tries to give us that understanding what they meant by nomination paper. Because, for instance, that's in 115, which you cited. Now, we understand that what usually signs by politicians is expression of interest form and nomination paper. So at the point where you do that, you are an aspirant. You don't sign that form as a candidate. And so they say that even though 115 may have been loosely drafted, but what the intention is by those who drafted is they're trying to avoid that kind of scenario wherein you pick up an expression of interest and nomination paper as an aspirant, having two separate forms in the same election. So if that were the case, isn't this narrative part of what they're trying to also avoid?
Chamberlain, we're in a very challenging moment where the Constitution of the Federal Republic of Nigeria is being terribly tampered with. And everyone comes up to give any kind of interpretation. Are you talking about what is in the Electoral Act, or you are talking about an intention? Your intention may be different from the intention of another person. So we are here to talk about what is in the Electoral Act. The Electoral Act says, as a candidate, and that's the underlying word. So has anybody purchased two nomination forms as a candidate? And the answer is no. And I'm also telling you, I'm doing an argument on two fronts. That when a primary has ended, that matter, that chapter is closed. You are no longer holding any form, of the party. That matter is closed. It's like somebody who is dead, So, and I said to you, even joining your argument, and then on the 9th, which is over 30 days, another chapter opens for primary election because the candidate withdrew. And then we joined. So what is wrong with that? So understand two things. Legally, you cannot import another definition of a candidature, as defined by the section 152. No matter how much you try, no matter how much anybody comes to this thing to shout, the law is the law. This section 152 has defined who is a candidate. And it is just the INEC who determines who is a candidate based on the primary election, the party would have held. Now, arguing along your own line, which is what the society has darkened. The society has a way of, attacking their leaders. I'm sure that if the governor, maybe Senate President and former Governor Akwa Ibom, were not involved, nobody would be hearing all this. And that's why nobody ever came to go to section 152 to define who is a candidate and who is an aspirant. Chamberlain, at the level of the party, everyone is an aspirant until primary is held. And then a candidate emerges. And that candidate is still subject to the confirmation by INEC in line with the electoral law.
All right, Your Excellency, we'll go to break, but we'll be back and get more from you when we return. Stay with us.
Your Excellency, thank you for staying with us. We're still speaking with the Governor of Ebonyi State, Governor Dave Umahi. I'd just like to find out from you if you're going to be pursuing this matter. I imagine that you'll be pursuing this matter to a logical conclusion. That's correct?
Thank you very much, my sister. Which aspect of it are you talking about my pursuing?
Well, we understand that right now there is just a moment. We understand that there is a nullification. You have explained the difference between a disqualification and a nullification. Apparently, you're hoping to participate in the primaries, the senatorial primaries of your party, and it's not clear from what the court is saying if you're still going to be pursuing that in the Court of Appeal.
There is something I want to leave with you, and and that will help you very much. And that is, I will read the Electoral Act, and it is very important so that you will be properly informed about qualification of an aspirant. Section 84, subsection 3 says, a political party shall not impose nomination qualification or disqualification criteria, measures or conditions on any aspirant or candidate for an election in its constitution, guidelines, or rules for nomination of candidates for election, except as prescribed under section 65, 66. Now, section 65 of the Constitution is dealing with 65 is dealing with the National Assembly. Section 66 of the Constitution is dealing with the House of Assembly. Section 107 is dealing with the President. Section 177 is dealing with the Governor. Section 187 is dealing with Deputy Governor nomination. Now, there is no any other qualification for a candidate outside this. And if you go to section 65, on this particular matter, that's qualification for you to contest, as a senatorial aspirant. You will see the qualification. So anybody talking about qualification outside this section is making a very serious mistake. Now, a section of the Electoral Act says that nothing should stop a scheduled, primary election. Now, the learned judge has scheduled, an election. Only the appeal court can stop it. So there is no any other litigation at the lower level that can stop that rescheduled, fresh primary that as pronounced by the judge from what they told me. Now, it is up to me to decide whether I'm participating or the person who won the election before is going to also come up, or any of my boys or members of my constituency will participate. So I'm not going to be telling you, my sister, on this, and I'm not going to be telling whether I'm going to appeal court or not.
Okay, so you're not going to be disclosing what your next line of action is. But just as an aside, and it's your right to withhold it if you want to. I'm sure a lot of Nigerians would have been interested to know what it is that you're going to do. But just, as an aside, there are still those who are wondering, I mean, given what happened with the presidential primaries of your party, and the candidate has since been decided, he's since picked his running mate, it's not been without controversy. There's been talk as to whether or not you are supporting the decision of the party and his decision to go with the running mate that he has picked.
Hello, Mogbe, I didn't hear can you hear me?
Are you supporting your party's candidate, a presidential candidate, with his choice of vice president?
Hello, can you hear me?
I can hear you clearly. Can you hear me, Your Excellency? The question I asked is whether or not you're supporting your candidate, your presidential candidate, with the choice of his vice presidential candidate.
Oh dear. Well, if you can hear us, Your Excellency, the question Mark was trying to put across is if you're supporting the candidate.
Yes, I can hear you. Yes.
Oh, great. If you're supporting the candidate of the APC with the choice of his running mate.
Yeah. Whether I'm supporting the choice of APC with the running mate.
The presidential candidate of your party with this choice of a running mate.
I want you to know that I don't know whether you can hear me.
Yes, please. Go ahead.
Can you hear me?
Loud and clear.
Yeah, there is echo. Yes. When we signed our nomination forms as presidential aspirants, we all committed to supporting whoever that would emerge. And I'm a man of character, and content. And so when His Excellency Asiwaju emerged, we all committed to supporting him. So whether I'm in agreement with the choice of his running mate or I'm not, I am bound by the oath we took to support, the oath of commitment to the party to support the party, the APC. And so I support my party in all elections.
All right, Your Excellency, we thought at least you were going to disclose some of those information to us since today is your day. But we have to thank you very much indeed for coming on Sunrise early this morning, and happy birthday.
Chamberlain, thank you very much. Let me just say one last thing, Chamberlain, if you permit me.
Okay, go ahead, sir.
Yeah, I want to say that, we should be properly informed about the Electoral Act. And when people come to the pages of the newspaper to talk, they should be, properly informed. And I've just gotten information from my boy who went to court to collect the court judgment. And the court did not disqualify me, and the court, said what the INEC lawyer told me, that he ordered for fresh election. And so the issue of Section 115 should be tied to Section 152, and that matter should be laid to rest.
All right, Your Excellency, we thank you. We do understand that, lawyers have different interpretation of the law. That's why they're lawyers, and then eventually they end up going to court to decide that matter. But thank you very much indeed, and have a great one.
Thank you, Chamberlain. Thank you.
All right.